5 myths and misconceptions that people have about sexual assault cases.
Roland, the first thing that comes to mind when you talk about this is this notion that people have that you actually need to have a lot of evidence in order to accuse and, more importantly, to convict a person of a sexual assault crime. And that's just simply not true under California law.
No, that's certainly not true. Under California law, there's a jury instruction, Cal Crim 1190. And what 1190 says is that specifically in sexual assault cases, testimony of the complaining witness by itself is sufficient to support a conviction. No corroboration is required to convict a person. As long as you believe the victim or alleged victim beyond a reasonable doubt, and a lot of people really don't understand that and how deadly that can be in this type of case.
So that means that if the little kid just gets up there on the stand and says, "Hey, he touched me," and the jury believes it, you go to prison. And if a pretty young woman gets up on the stand and says, "Hey, he raped me," and the jury believes her, you go to prison. Even if this allegation happened 5 years ago, 10 years ago, 20 years ago, no one else has seen the behavior, there is no forensic evidence supporting this allegation, and there is no confession. No corroboration is required. And because of that, this can be really devastating to a person who is accused of a crime.
The second thing that comes to mind that we hear from clients when they come in our office all the time is, "Hey, can I just take a lie detector test? That'll clear me. I'm sure I'll pass it."
It's very interesting that you bring up the lie detector test, because I think that the general public is under the impression that somehow there is this magical tool that an innocent person can get plugged into and it will produce clear and definitive results of a person's innocence. And while this tool does exist, because after all, lie detector tests are available and we've used them in the past, the reality is that the law in California today actually makes the results of a lie detector test legally inadmissible in a jury trial. So even though there are some legal circumstances where these tests can be used, for example, they can certainly be used for plea negotiations, for informal discussions with the district attorney. They can be court-ordered, which I find personally to be somewhat disingenuous, but they can also be court-ordered for purposes of sex offender counseling or treatment once a person has been convicted of a crime and placed on probation or parole, for example. And even though a court can find a person, for example, in violation of probation or parole for failure to comply with a lie detector test or lying on that test, these tests are just not considered sufficiently reliable, Roland, in order to help an innocent person clear their name when they're facing false accusations of sexual assault. And I'm worried that the general public doesn't always know that.
And the third misconception that we hear all the time is we have parents or brothers or even our clients come in. They say, "Well, the other person is very sexually active. They're with 12 different people. Doesn't that count for something?"
That's very, very true. Oftentimes we're dealing with cases where our clients will report or our investigation will reveal that a complaining witness is sexually promiscuous, that a complaining witness perhaps has a lengthy history of promiscuous sexual behavior. And to our clients, to their parents, to their family members, and quite likely to future jury, this all appears to be very strong, very powerful evidence that this person should not be believed, especially on the issue of consent. But unfortunately, in California, and specifically under Evidence Code Section 1103, for example, evidence of victims' past sexual behavior with others in particular is legally not admissible to prove certain issues, such as consent. These are rape shield laws in California, and they were enacted in order to protect victims or alleged victims of sexual assault. But unfortunately, this is the downside to them, and it could really hurt an innocent person. Now, there are some exceptions to this rule, for example, and some of these exceptions may allow creative lawyers to admit some of this evidence in a person's trial if, for instance, it goes to issues of someone's credibility under Evidence Code Section 780 or 782. But generally speaking, California rape shield laws prevent evidence and prohibit evidence of victims' past sexual behavior from being introduced in a criminal jury trial. And that's true even when this is something that there is a lot of evidence of and where it may frankly be quite probative on some of the legal issues. You have to file a special motion. You're going to have to withstand very critical scrutiny by a judge who is likely going to favor a victim in a sexual assault case for a variety of reasons, including some political ones. And it is exceptionally difficult to get that evidence admitted. But most of the people in the general public absolutely are not aware of that.
The fourth area in misconception that we deal with that we wanted to cover is taking the stand. A lot of people believe that ultimately, when that person comes and takes the stand, they're going to tell the truth. In practice, we haven't found that to be the case, have we?
I agree with you. Sadly, we discovered that by the time a criminal case actually goes to trial, which could be in 3 months, in 6 months, 9 months, maybe a year later, the person who has made the allegations of sexual misconduct, sometimes an adult, often a child, has been so far removed from the alleged offender, they have been so brainwashed, so trained, and so indoctrinated that by the time they come to court to testify against you, you will not recognize the person you once raised, you once lived with, you once loved, the person you interacted with. So it's always a shocking and surprising experience for our clients, but unfortunately, it happens all the time. And similarly, when our clients take the stand, they seem to think that as long as I get up on the stand and I testify a certain way about what happened, I'm going to be believed. But that also is not always true. Sometimes jurors don't believe people even when they tell the truth.
When you're dealing with children, they have practice court. They take the kids in the courtroom, they practice asking and answering questions with them. They go over an interview that they did 2, 3, 4 months, maybe years ahead of trial, and they make sure that they're exactly on script, that everything they said before is the same. They have a support dog, they have stuffed animals, all these things to make the children feel comfortable and create a positive reinforcement for them. And the problem with that is that by the time these children actually take the stand, it's going to create an impression of a confident child who vividly remembers what has happened to them as opposed to a well-practiced one.
And I think a lot of people don't realize that witnesses before trial are usually prepared. And that's true for both sides. But in particular, when you're dealing with someone who has made allegations in the past, who has perhaps been interviewed 3, 4, or 5 multiple times, they may have given statements to several police officers. They may have given statements to a lead detective. They likely have been interviewed by a forensic social worker. And now they're being trained on how to answer these questions properly. Perhaps not directly, but indirectly. So all of that results in a witness coming to court and, Roland testifying with confidence about things that happened, when in fact maybe these things didn't happen at all, or did not happen quite in a way that they're describing.
The fifth area we'd like to talk about today is the area of pseudoscience, a highly misleading type of expert testimony that has been developed and is very widely used in order to help prosecutors obtain convictions in sexual assault cases, particularly involving children. This is something called CSAAS, Child Sexual Assault Accommodation Syndrome. This is a theory allegedly admitted to disabuse the jury of misconceptions it may have about how children behave and report when something happens to them, and is especially misleading because basically anything a child says, these doctors will testify that it's consistent with child abuse.
Yes, and to go into it a little bit more, usually what we see in a case involving, for example, a child who may be falsely reporting that abuse happened when it didn't, is something like this. Sometimes a child waits to report for a very long time. So naturally that raises a question. Well, hey, if all of this horrific abuse allegedly happened to you, why wouldn't you have mentioned it to your grandma? Why wouldn't you have mentioned it to your mom? Why wouldn't you have mentioned it to your auntie who was picking you up and driving you safely one-on-one to school for the last 6, 7, 8 years? Why did you wait until you were 17 years old and got in trouble in school to report this incident? And so that's obviously a problem area for the prosecution. And in the past, Roland, when you and I were just starting out in our careers, 15, 20 years ago, jurors would nod their heads and say, yeah, that's a big problem. Why would you wait for so long? Are you telling us the truth? But see, now they will call this fake expert who will charge the county exorbitant fees, often in the thousands of dollars, and they will come to court and say, well, based on my experience working with children who have been victims of sexual assault, children may not report that something happened to them for a very long time. So even if the child waits for a ridiculously long time, it's entirely consistent with being abused. Or you could have, for example, a child making different statements about what happened, being totally inconsistent with what they reported from one person to another. And so obviously, again, if you're a defense attorney, you're going to ask some very probing questions like, hey, when you first spoke with your grandma, you said that nothing happened. When you spoke with your aunt after that, you didn't report anything. But then you get in trouble with your teacher, and suddenly you're saying completely different. And then you were interviewed by 3 police officers and a social worker. And each time your story had a little bit of a discrepancy here. So obviously, once again, clearly a problem area for the government when the witness is all over the place. But in these types of cases, they will call their trusted fake expert, pay them thousands of dollars, and this academic type will once again take the stand and testify that in his or her training and experience, this behavior also is consistent with abuse. So this is just a really bad science, Roland, because no matter what the evidence is in the case, these paid fake experts are going to come and tell the jury, hey, don't worry, you can still convict. This could totally be true regardless of any doubts you may have or frankly should have. And since the child is cute, confident, has now practiced telling their story multiple times, there is this nice professor with a bow tie telling you that these problems don't matter and the child may well have been abused. Regardless of these inconsistencies, this creates a very high risk of false conviction, even if the person is completely innocent.